In order to understand what's going on here, it helps to know that there are two big goals in bankruptcy law. The first big goal is to give the debtor a fresh financial start. It has a great pedigree. It's in the Constitution, in the Bible, in Roman law, in the ancient Hittite Empire's law, in Hammurabi's code. So that's our first big goal in bankruptcy law, to give the debtor a fresh financial start. The second big goal in bankruptcy law is to make sure that all creditors who are similarly situated are treated equally and fairly. And by the way, some vocabulary, sometimes people get confused. The debtor is the person who owes the money. The creditor is the person to whom the money is owed. So sometimes debtors will either purposely or inadvertently violate this second big goal of making sure that all similarly situated creditors are treated equally and fairly. The first way they'll violate that big goal is they won't list all their creditors in the bankruptcy papers. That's a serious no-no. You don't get to pick and choose. And it's just a matter of fairness if you think about it. If one creditor gets listed and the debt goes away, the other creditor doesn't get listed and gets paid, the creditor whose debt was discharged is going to complain that that's not fair, that the other guy is getting paid and they're not getting paid. But that's really not getting at your question. The question is dealing with what happens if you make payments in anticipation of bankruptcy. So that's the second way in which debtors will sometimes violate this big goal of treating similarly situated creditors the same. They'll make preferential payments to a given creditor in anticipation of bankruptcy. Now, maybe they're hoping to curry favor that creditor, or maybe the creditor's a relative. I mean, I'm going to take care of my brother. Well, if you make that payment to your brother, you are treating your brother better than other similarly situated creditors. That then is called a preference, because you're preferring that creditor above other similarly situated creditors. Now, in bankruptcy, a trustee assigned to the case, or if it's a Chapter 11, the debtor in possession, is empowered to undo that transfer and recover the funds, not to give back to the debtor, but so that that money is available to pay all the creditors so that everybody gets treated the same way. That kind of action to recover a preference is called an avoidance action. It's a somewhat unusual usage of the word avoid. It means to render null and void. And so if you start making payments to a given creditor in anticipation of bankruptcy, you're going to need to wait. Because if you file too soon, then the trustee can avoid that preference. Well, how much time do you have to wait? Here it depends on the kind of creditor. And in the taxonomy of debt, there are different ways to break things down. One way is to distinguish between what are called ordinary creditors and insider creditors. So let's define what we mean by an insider creditor, and then whatever's left over is ordinary. So a creditor is someone to whom you owe money. An insider creditor is a creditor who is also either a family member up to 3 degrees of consanguinity or a close business associate in a way that can be made precise. All other creditors are ordinary creditors. Now, if you make a preferential payment to an ordinary creditor during the 90-day window immediately prior to the day you file the bankruptcy papers, that's considered a preference, and the trustee can avoid that transfer. And it's measured not from the day you write the check, if you're paying by check, but the day the check is honored by the bank. And there is a U.S. Supreme Court case holding precisely that. If the creditor is an insider creditor, then the trustee can go back a whole year. So if you've been making payments to your dad or to your brother to pay a prior debt, well, you're going to need to wait a while. Otherwise, you're going to have the trustee go after that relative, and that relative is not going to be pleased. In any event, don't make payments prior to filing is the slogan that I give to my clients who are debtors, who are thinking about filing for bankruptcy protection.